I'm Larkin. I'm Larkin Timmer Parker. I'm the legal director of the Autistic Self-Advocacy Network. And this afternoon, I'm going to talk to you all about 504 regulations. Thank you. So this is going to be a longer webinar than usual. We don't have to take up all of the time, but we're going over some history and a complicated regulatory process. We also wanted to leave time for questions and discussion if that ends up being beneficial to anyone. We're going to talk about what the Rehabilitation Act is, what's going on with it now, why that's important, and what you can do to have input into the process. So let's start with what the Rehabilitation Act is. Can everyone hear me? See in the comments that someone's having trouble. Okay, thank you. Yeah, Aaron, I think it may just be technical difficulties on your end. I hate for you to miss content while we work this out, but this is going to be recorded. Worst case scenario, you should be able to check our website for it later. And to be respectful of everyone's time, I'm gonna proceed. Hope your sound starts working again, or you can use captions. So what is the Rehabilitation Act? It's our oldest federal disability rights statute. And it's older than most, if not all, state disability rights statutes. Its purpose is to prevent discrimination against disabled people by federal organizations and anyone using federal funds. That's a really powerful tool for the disability community because federal funds are all over the place. Federal money flows through healthcare, education, housing, many industries. This law can even sometimes reach into religious organizations to the extent that they use federal funds to do charitable work. And our other disability rights laws at a federal level don't do that by and large. So that's really important. It affects employment, especially within the federal government, for federal contractors and other organizations where federal money is in use. It's about 50 years old, turned 50 this year. It was passed in 1973 and was the culmination of a disability advocacy effort that went through veterans of the world wars, polio survivors, and the independent living movement that really gained strength in the 60s and 70s. And like most laws, most of our federal laws, it's a big sweeping statute. Federal laws aren't really fleshed out enough to be meaningful. The typical big federal civil rights statute is so broad and so general that it needs implementing regulations. It needs regulations created by federal agencies that fill in the specifics, that explain how the really grand purpose stated in the statute is going to play out on the ground in people's day-to-day lives. That's the norm for federal statutes, including our federal civil rights statutes, and the Rehabilitation Act was no exception. it was passed into law, and it wasn't really enforceable until it had some implementing regulations to fill in the details. Next slide, please. Even when it wasn't really enforceable before it got regulations, 504 was revolutionary in that it established disability as a protected identity. It recognized disabled people as historically marginalized and stated an intent to do something about that. And it promoted the full integration of disabled people. The Nixon and Carter administrations were slow to finalize those implementing regulations that are very important for a law to actually work and do what Congress intended it to do in people's day-to-day lives. Those regulations would say things like, the statute itself would say things like, don't discriminate against disabled people, but the regulations would spell out how different kinds of organizations covered by federal money would actually have to behave to avoid being liable for discrimination. So it was really frustrating to advocates at the time that these regulations weren't coming out, that they weren't a big priority for the Nixon and Carter administrations. And why that matters is that Congress creates these laws that state a purpose and fill in some of the details, and then federal agencies have to fill in the regulations and get really granular with how the laws are going to work. Next slide, please. Activists eventually got tired of waiting, and a real who's who of people who were doing disability activism and other kinds of activism on the West Coast in the early 70s, people who would go on to do a lot more very important things, got organized and decided to create some pressure, get this issue on the news, and get the regulations passed. So the activists organized the longest nonviolent occupation of a federal building in US history. It dragged on for 26 days. A large number of people, many with disabilities, just camped out in a federal building and refused to leave. These activists were led by Judith Heumann and Brad Lomax, names you may have heard from their later work. And the occupation took place in the San Francisco Federal Building. This really was the era of the growth of the independent living movement. There was a lot going on in California. That's why it happened there. I want to call attention to what Sam Johnson is saying in the chat, the Judy Heumann episode of Drunk History. There's also an episode of Stuff You Missed in History Class, I think it is, on this event, if you want to hear about it in more detail. This is an incredibly important watershed moment in disability history. It matters because it was intersectional and it showed the power of our movement, particularly when it aligns with other movements demanding rights, liberty, justice for marginalized people. Groups including the Black Panthers and the International Association of Machinists, and many others, like a real who's who of activists who were around at the time, helped with this. And it wouldn't have been possible without people willing to stay inside the building, people on the outside doing things like conveying messages, groups sending food. There was a lot of intersectional organizing and effort here. It's also an important moment because this was a point where disabled people really stood up for our own rights and for a chance to fully participate in society, and put aside and really pushed back on stereotypes of disabled people as helpless, as deserving only of pity. This was not asking nicely for regulations that would make 504 something meaningful, something where you could hold up a piece of paper and show someone who was discriminating against you what they were doing wrong, something where you could hire a lawyer and go to court if they wouldn't back down. This was us demanding our rights. A really proud moment for the disability community. Next slide, please. The regulations were enacted. They were finally signed by the head of the relevant federal agency, and they took on the force of law after going through the whole agency process and finally being adopted. And they have offered people with disabilities some protections for the last several decades. Those protections have been augmented by things like the ADA, an update to the ADA that was passed in 2008 after courts kind of gutted it, the non-discrimination provisions in the Affordable Care Act, and some state disability rights statutes. But the thing about 50-year-old regulations is that a lot of social change has happened in the last 50 years. A lot of technological development has happened. What society looks like, what people do for recreation, for a living, what's normal in terms of the kinds of communities that people live in, even family structure has shifted a lot. The world looks very different than it did in the early 70s. So there's a lot that's still beneficial within the Rehabilitation Act. People file litigation under the Rehabilitation Act and use it to vindicate their rights all the time to this day. But it is a little dated. The regulations are a little dated, and they don't necessarily cover some newer problems that the disability community is facing, or some old problems that are now more talked about and more visible because our community has made progress, is more organized, and has had more years to gain ground in terms of advocacy. What this means is that a number of federal agencies are putting out an update. This is really historic. It's incredibly important. It's a chance for the disability community to have input into what the regulations under this important disability rights statute will look like for the next few decades. This is an opportunity that for many of us, maybe once in a career, once in a lifetime, to participate in the drastic overhaul, big sweeping changes to these regulations that determine what the Rehabilitation Act protects in the lives of people with disabilities day to day. Since this is a big, important law, multiple federal agencies are going to have to participate in this process. Right now, the one that has released a proposed regulation and started the process of creating one of these regulations that, when it's finalized, will take on the force of law, is the Department of Health and Human Services, or HHS. We're expecting to see, again, proposed rules from a number of other federal agencies. We may reach back out to you all to talk to you about that in the months to come. But right now, what we're dealing with is HHS. And the proposed rule that HHS has set up, has released to the public, covers things HHS deals with and funds. So we're not discussing every aspect of disability discrimination here, or every problem the disability community has. We're just discussing things that are covered by HHS. But that's a lot of really important things. HHS deals with medical settings, public health, social services, and more. Next slide, please.
So I wanted to read out, we have a couple folks in the comments. We have Frida Tepfer saying the PROWAG public right-of-way accessibility guidelines were at last finalized by the Access Board in September after 30 years. Department of Justice and DOT still have to adopt them for them to be fully functional. Then we have Anna Gray saying you should not have to just provide input. You should be part of the government. It should be illegal to have any federal agency that affects the rights of autistic people to not have at least 50%, preferably 80% autistic staff.
To answer Frida's comment, yes. The enactment and adoption of regulations and agencies going through the full process to get their regs to take on the force of law is really important. And it causes problems in people's lives and can gut the entire promise of a statute that people have worked really hard to get in place when that doesn't happen. I'm not familiar with the statute you're referencing or those guidelines, but that can be a big problem when agencies don't prioritize getting this done. Anna, that's a really interesting idea, but I don't know what federal agency doesn't affect the lives of some autistic people somewhere. And I'm not sure it's practical when we're a relatively small slice of the population to require 50 to 80% of agency staff to be autistic. That said, I do really hope to see more disabled people in situations of engagement and authority over disability issues. And one thing that I really value and appreciate about our disability rights statutes is that in the last 50 years, it has become much more possible for us to get into professional roles working on our issues. Is it common enough even today? No, I don't think so anyway, but I think that as we keep using these statutes to open up professional and educational opportunities, we do have the opportunity to make this more and more common and to have more and more say. making a comment on aspects of these regulations that you feel strongly about is another way to have a say.
We've had another question in the chat from Hector Ramirez. Can we submit comments in any other format besides written? What about video recordings?
We were going to get to that later, and unfortunately, the answer is no. What I would do if typing something out is not accessible is try to use transcription software. There is some out there that's free, it's not perfect, and it may be more accessible to some people than others. But either doing that or seeking someone else's assistance is probably the way to go. Oh, Nicole, that's great advice. I think it may be built into some Apple software as well. But yeah, comments do have to be in a written form. We'll talk about how to submit comments, like the actual mechanics of getting what you have to say submitted if you choose to do that a little bit later in the presentation. So unless there are any more pressing questions or comments, thank you. Nicole is providing more details about how to do this in Windows, saying you can use the Windows key plus H to open the speech to text feature on Windows. Very helpful, thank you. So let's talk about what's changing. Mostly what's happening is that protections in the existing 504 regulations are being left alone. There's not a lot that HHS has cut out. What HHS is trying to do is add protections. And those protections are designed to address common disability problems today. Those problems come from a variety of sources. Some issues in healthcare access, discrimination in healthcare, things of that nature have been around a long time and have been well known in our community for a long time, but they got a lot more mainstream attention during the early part of COVID when they made the news and were on everyone's minds for a while. So some things in this rule are designed to address issues that people have just become more aware of in recent years. There are also things in the rule designed to address problems that are very real and significant, but are in some ways signs of how far we've come. Like the child welfare issues that are coming about now in a way they might not have in previous generations because more people with disabilities are living in the community in conditions where having children seems possible. More people are being allowed to have consenting intimate relationships that may result in the birth of a child. So some of these problems actually arise from our progress, but they're real problems and they need to be addressed. Some of these problems also arise from things like medical progress. Before organ transplantation became as prevalent as it is today, discrimination in the transplant process wasn't an issue. So a lot of our changes are just to keep up with social and technological developments and things that our movement has won. There are also some changes in the regulations that are about consistency. we talked about how other disability rights statutes have come about at the federal level since the Rehabilitation Act. The Rehabilitation Act is the oldest, the original, the kind of prototypical disability rights statute, but it's no longer the only one. And over the years, there have been tweaks to other federal laws in the course of litigation and court decisions that affect large numbers of people because they happen at the Supreme Court or they happen at the courts of appeals, have changed how different laws are interpreted. And HHS is trying to make the way the Rehabilitation Act works consistent with the way laws like the ADA work. Next slide, please. Let's start with healthcare discrimination. I think this is one of the most critical parts of this rule for the IDD community, as well as many others with disabilities. This is an issue that is really going to cut across the disability community writ large. The rule includes some very strong language in the text of the rule itself and in examples that are kind of designed to illustrate how the rule should be applied and teach people about the rule, about how providers are not supposed to do things like push people with disabilities away from care that's normal, that's just the standard of care, that's what most people would get if they went into a hospital, just because they're disabled. The rule is also designed to crack down on providers making judgments about patients' quality of life. We saw this a lot in situations where COVID made healthcare resources very scarce because demand was high. But even before the pandemic, I bet a lot of us had heard stories or had personal experiences where maybe ourselves or a loved one, an acquaintance, had been pushed to pick palliative over curative care, over care that was meant to extend life, because of medical providers' assumptions about quality of life. HHS has recognized that negative stereotypes about people with disabilities' quality of life in medicine are a big problem and is trying to address that, cutting into quality of care and whether people get care at all. Now, this doesn't ban hospice, and this doesn't ban palliative care, certainly, which is hospice is end of life, and palliative can come into the picture anytime someone has a condition that's causing them suffering and likely to go on a while. But it does limit providers' ability to impose their own sense of what a good quality of life is on a patient who may have a very different view. Nina, thank you for your question. I'll respond to it when we get to integration. There are also specific mentions of things like organ transplantation and crisis standards of care, where we've seen big problems with disability discrimination. And we've not just seen problems with discrimination, we've seen specifically problems with discrimination in circumstances where discrimination is really life-threatening. Next slide, please. Another nice thing in this rule that's very important for a lot of people with disabilities is that this rule will require healthcare systems to do more to have accessible medical equipment. There are specific standards set for that. And this will help a lot of people with physical and mobility disabilities get quality medical care and get things like routine screenings that can be life-saving. There's also specific discussion of the way in which someone may need help in making their healthcare decisions in terms of communication or supported decision-making, including language that says somebody doesn't have to have a formal, written down on paper, supported decision-making agreement to be able to use the help of a supporter and to insist that their healthcare providers respect the involvement of their chosen supporter. Next slide, please. This is changing gears a little bit. But one thing that HHS is very involved in besides medical care is child welfare. Child welfare happens at a state level. DSS, foster care, even child custody, as it happens in divorce, happen in state courts through state agencies. This is not directly a federal issue. The people doing this are not federal employees, but this is a place where a lot of federal money flows, and a lot of that money is controlled by HHS. It's also an area where people with disabilities, people with all kinds of disabilities, but particularly IDD and mental health disabilities, have had really significant issues, both parents and children. It contains language to protect families with disabled parents from removal just based on stereotypes and assumptions. And here's the really exciting part. It protects families from being broken up solely on the basis of a parent's IQ. The rule is designed to promote equal opportunity in family preservation. So DSS workers having to accommodate people with disabilities in the family reunification process, in things like parenting classes, and in anything else where someone might need a reasonable accommodation to meet a state's standards for being able to keep their kids. This also cautions states against discriminating against disabled people who seek to become foster parents or take in children within their families as kinship caregivers. I find this all really exciting because while it's certainly not true that all disability is hereditary, a lot of it isn't. Some is. And one area where I particularly worry about children with disabilities of the kinds that run in families sometimes is that if they're taken away from their families and everyone who might have a similar disability is excluded from the foster care system, they're losing a lot of beneficial information from adults. They're losing a lot of access to adults who know how to navigate life with the disability they may develop. And that may really impede their growth and development as young disabled people. And we know children in state custody are disproportionately people with disabilities. I'm looking back at some of your questions now, trying to get to several of these. Anna Gray says, I cannot go to ER. I have severe sensory sensitivities. I develop seizures and convulsions, as well as temporary blindness, partial paralysis, and cognitive failure from any noise over 60 decibels. Noise in the ER is over 70 decibels. And when person is in pain, their resistance to sensory unfriendly environments is going to be lower, not higher. I agree, that's a real consideration. The first time I had heard public attention called to the level of noise in hospitals was during the first few months of the COVID pandemic, maybe that first winter. And I think it's an issue that's still under discussed. It's not an issue that I think this rule will address. That's a problem we still have to solve. Vanessa Shea says, my context for this is in the field of pediatrics. Medicaid just launched an expanded benefit for kids that covers a lot of this, but requires so much advocacy because of chairside denial. Does the requirement for healthcare roll into mandates for insurance coverage? Unfortunately, no, there's not a lot about insurance coverage in the rule. This is the right way to think of the healthcare sections of this rule is that it's really about what happens at the bedside, not what happens in the whole healthcare system. And on the one hand, there are problems that really need to be solved at the bedside that are killing people. On the other hand, this doesn't solve every problem people with disabilities are facing in healthcare. It's going to make some big improvements, but it's not going to solve everything. Roxanne Yakupi says, does the rule address child welfare in terms of children in group homes, mental health facilities, foster care facilities, etc.? Yes, and this kind of gets entangled with the integration language we'll get to later. One thing the rule does that I'm very excited about is that it pushes states to not institutionalize kids in state custody so much, which is a big problem. Chase Eagleson says, I missed the health accessibility slide. Could anyone share what it said? Chase, there were, I think a couple of slides on most topics. This is all going to be available for you later. Nicole Damiano says the diagnostic tools for ID have moved away from solely looking at IQ and consider functional abilities. Yes, and that's what HHS is trying to encourage people to do. Also, thank you for sharing your note with Chase, Nina. Nina says, Chase, here are my notes on the healthcare accessibility slide. Healthcare accessibility expands the type of medical equipment that needs to be accessible. Now included equipment for examination, diagnosis, and treatment, protects our right to bring a support or communication partner with us in medical settings without a formal supportive decision-making document/agreement. Anna Gray says IQ is an ableist test. I agree, particularly when it comes to parenting ability. There are a lot of problems with IQ as a metric that are well documented, but it's a particularly weak predictor of parenting ability. There's really good research addressing that. There has been for years. And that's why I'm really glad that this rule is pushing states to do what they already should be doing, but in many cases aren't, and look at functional capacity instead of IQ. Anna Gray says, I think that seminar will be available later on YouTube channel, and Anna posted a link to our YouTube channel. Yes, this is being recorded. It should be available later. Chase says, Nina, thank you. Alex says, well, Anna, we will upload this webinar and it should be available by the end of the week. Catherine Hedges says, if people get better care at the primary care level, they may not need hospital care. I'm glad you will be publishing this webinar. I need to jump off at 1 for a local organizing Zoom. Catherine may be gone by now, but if you're watching this recording later, yes, exactly. A really scary consequence of the lack of accessible medical equipment, especially for wheelchair users, is delayed diagnoses of things like cancer. And we know that when cancer is diagnosed early, it's a lot easier to treat. In many cases, it's a lot more survivable. So someone getting diagnosed a year later could be the factor that determines that they die of cancer instead of surviving their cancer and living for many more years. So it's hard to say how many lives those provisions will save, but I bet a lot. Alex says, yes, this webinar will be posted after it is finished and available to watch on our YouTube channel. Catherine said, this webinar is so good. NACDD will be sharing the recording and your toolkit with our networks. Thank you. Great job, Larkin. Thank you, Catherine. Next slide, please. So here's where we get into the integration mandate. And a lot of the changes here are really designed to follow the Olmstead decision that says that when states are going to provide a service to anybody, they've got to offer it in the community for people with disability. When they're going to provide disability services to anybody, they've got to offer it in the community for people who can benefit from that and want to, rather than just offering it in institutional settings only. I want to get into this question we got from Nina, which does the word integration on the previous slide, what's changing, refer to Olmstead, mental health care, HCBS, employment, housing, none of these, some but not others, or something additional? The integration mandate provisions in this rule apply to whatever HHS funding touches, which is not usually going to be employment. Maybe a little bit in a roundabout way when people with disabilities are employees of HHS funded entities or HHS itself. But we're only talking about things that are within the jurisdiction of HHS here, which means that a lot of this integration mandate statement, which says that providing people with disabilities what we need in the most integrated setting possible is required, is going to apply in circumstances like medical care and foster care, where you can find a lot of federal money, specifically HHS money. Sam Johnson says the Olmstead decision was over. Oh, we've got a few more comments I'll address before moving down to Sam's. Sure, Alex, that would be good.
Let me actually give you my face. All right. It looks like, okay, here we are. RV has said, does this proposed legislation cover anything about accessibility issues with health records, especially how info gets relayed into your chart? I just had a terrible experience at a major university hospital radiology department. Not only was my husband not allowed to come back with me, in parentheses, women's health excuse, but info I had already provided was ignored and I got grilled to rehash my entire medical history, yet I can't see what's on their screen. I'm really sorry that you had that experience. And Larkin, I figure I'll let you answer this question before I read the rest.
Yeah, I'm really sorry to hear that. I hate that. It's all too common, but I'm so sorry that happened to you. I don't know that this would prevent that. I can't give you specific legal advice. I'm ASAN's lawyer, not yours. And I think it's always worth talking to a lawyer who's licensed where you are if you think that you're facing a legal issue. But I can say as a general matter that if somebody asked for a support person as a reasonable accommodation, that would be much more protected by federal law. If somebody connected, even now, even prior to the enactment of these regulations, which aren't finalized yet, if someone were to ask for a support person to go back into the room with them and connect that to a disability, even now, when these regulations aren't yet finalized, there are some good arguments under federal law that healthcare providers would, as a general matter, be required to respect that and help people with that. And if that's an ongoing issue you're facing, I think having a chat with your PNA, your protection and advocacy system, which is information you can find through Google, or if you have trouble, you can email me about it, wouldn't be a bad idea. The chart issue, again, can't provide legal advice, which would mean applying the law to the facts of your specific situation. But what I can say generally is that if somebody needed communication accommodations to look at information for patients in their chart, like somebody needed an online portal to be screen reader accessible, or needed something like large print or braille, that is a fairly common, reasonable accommodation that people ask for in life. If it's just that providers aren't attentive to the contents of a chart, that seems like situations where providers just aren't attentive to the contents of a chart and aren't attentive to what patients have already told them seem less like disability issues than the ways in which healthcare is kind of broken and very flawed for all of us for big systemic reasons. And something to remember about our disability rights statutes and all the regulations attached to them is that they only protect people from disability discrimination. A lot of bad things are not banned by our disability rights statutes and their regulations if they're bad things that could happen to pretty much anyone. So no, these will not protect anybody from the brokenness of our healthcare system.
Thank you, Larkin. And from Anna Gray, we have, I almost died from cancer due to late diagnosis because of doctor's ableism. I did not display regular symptoms. My mother had to threaten the hospital for them to finally agree to treat me. I suffocated from tumor and had a heart failure. And I'm very sorry for your experience and how frightening and frustrating that must have been for you. And then
I'm sorry to hear that.
We have Catherine Hedges. I'm concerned that permanent supportive housing is becoming a type of institution, which is a whole other topic.
Yeah, this isn't really about that. This is not something that is really addressed in the rule. The rule defines medical care in a way that really tends to cover things that happen in doctors' offices and things that happen in hospitals, things that are part of a treatment for a condition, not necessarily supports in day-to-day life. I actually kind of like that because we don't want everything in disabled people's lives medicalized. So that is an issue that needs to be addressed for sure. The levels of coercion and lack of choice in many residential settings, even if they're allegedly in the community, the way they don't pass the burrito test. But that's not really what this rule is or does, and the comment process for this rule isn't the best place to address that.
So then we have Sam Johnson asking, the Olmsted decision was over 20 years ago. Is this the first time the standards have been redesigned to match it?
For the Rehabilitation Act, this is the first time there's been a major overhaul of the standards ever. So yes.
And then we have Catherine Hedges again. Friend had to get a medical/psych exam to prove she had a disability to get PSH housing, as did everyone in the building. They're supposed to be receiving psych care and some health training, and will lose that and their housing if they want to live elsewhere.
That's another really significant problem. I think that gets at tying services to residential settings and all the dangers we know that comes with. It's a serious issue, but it's not among the issues, it's not on the list of problems this rule itself is designed to tackle. And honestly, I don't think that we want it to be, because it would probably get attached to medical care, and we don't really want housing to become part of medical care, since that's often the source of this problem.
And we have Shannon Rosa just giving apologies and saying that they need to leave, and apologies. Thank you. I need to leave. Thank you so much for the informative session. We live tweeted at least partially at Thinking Autism. Then we have RB with a thank you for your comments. Catherine, thank you everyone. So much great session. And sorry to take up bandwidth, bringing up an issue that housing is being medicalized. I don't think it's taking up bandwidth. I think it's an important conversation to have.
No, I would move us along if we were running out of time to cover everything we needed to cover in this webinar. That's a crucial conversation, and just because this rule doesn't address it doesn't mean it's not important. It's really, really key, and we'll talk about this a little bit later. I hope those who can't stay to the end will go back and watch the part about actually submitting comments, if you're not familiar with how to do that. Remember that this will be posted places and the comment deadline isn't until mid-November, so you've still got time if that's something that's interesting to you. But one thing that we're going to talk about a little bit later as we get into how to submit comments is that it's really important here to stay on topic. Our community has a lot of problems that are real and pressing and significant. The important thing in submitting comments on this rule is to stick to the ones the rule covers and just be laser focused on those.
We've had a couple more people comment in the chat, but I want to draw attention. Emily Taroni has left a comment in Q&A saying, I'm a fellow from Vermont, LAEND, looking at how these rule changes impact people with disabilities from culturally linguistic backgrounds. Do you have any input on how one or more of these changes helps this particular part of the disability community? Feel free to wait until the end of the webinar to answer if that works better for you. Thank you.
Emily, thank you for asking that. First, congratulations on your Lend Fellowship rather. That's something that I haven't seen very much in this rule. I do think this rule has very significant intersectional implications. A lot of the problems this seeks to tackle are going to affect LGBTQ people and people of color a lot. In many cases, I think in very positive ways. Some of the efforts to address discrimination in medical care and reduce the impact of stereotypes and assumptions in decisions about who is able to care for a child are really, really intersectionally beneficial, helpful, good. I don't know that there's that much here for people who speak English as a second language, or third or fourth, or don't speak English at all. That's a real issue in our medical and child welfare settings, in our disability service systems. And that is certainly a population within the disability community that's not always getting well served, that's frequently not getting its needs met. I don't think that this rule tackles that issue.
And going back into the chat channel, we have Vanessa Shea saying, housing is being medicalized with the transition in public health modernization. Then we have Catherine saying, about to leave, we'll definitely watch the call to action and share with other disabled folks. Thank you so much.
Please do, thank you.
Amy Fellows is saying, asking, do the Olmstead changes support when families provide a safe space for their adult disabled child to live with them, instead of the pressure DDS seems to put to make them, excuse me, I got tongue-tied for a second. Let me just read it over again. Sorry, y'all. Auditory issues. Do the Olmstead changes support when families provide a safe space for their adult disabled child to live with them, instead of the pressure DDS seems to make to have them in group homes and being cash cowed? And then Amy continues, also wondering if any changes to education/IDEA law.
So in terms of housing, where it applies, to the extent that HHS and HHS money are involved, yes, this would promote community settings over institutions. No, it would not necessarily always promote living with family over group homes. It also isn't always going to apply to housing, because so much of housing is either private money, people's own money, or it's other aspects of public money. It's just not always funded by HHS. And I think your question really gets into the issue that you and a lot of other people have pointed out over the course of this presentation, that we have issues with low quality community housing options. And we have issues with housing becoming medicalized and becoming very coercive. That's not what this rule is really aimed at, and it's not what this rule is going to most significantly change. It's a real problem, but I would not make it the focus of comments, because this rule is just designed to solve different problems from that for the most part. Education and IDEA are not going to be in this. We are expecting that the Department of Education is going to do its own proposed rule as part of updating 504. Last I heard, that's not out yet. We'll be back in touch, I'm sure, when it happens, but this is not the place to talk about education, because that's by and large not HHS's jurisdiction. And we don't know what's happening there yet, because we haven't seen a proposed rule out of the Department of Education, which is where anything like that would happen. This also is not going to change IDEA. or IDEA's regulations in any significant way, because the Rehabilitation Act is one statute and IDEA is a completely different statute with its own regulations. Now, when the Department of Education releases new Rehabilitation Act regulations, when its proposed rule comes out, I bet there are going to be implications for K through 12. It seems like there have to be. I don't know what those are yet because that hasn't been released, but I think it will change some things. It's just not going to change IDEA.
And Emily has said thank you regarding the answer to her earlier question. And then Anna has said all rules and agreements must be available as one page in plain English to be accessible to people with dyslexia, cognitive and intellectual disabilities. And plain language and easy read are crucial tools to make sure that folks know what their rights are and what changes are happening. Yes.
And Anna, thank you for bearing with my public speaking skills today. We're in the 2-week period of every fall where North Carolina, where I live and mostly work out of, just has terrible allergens. So I have a sore throat. I'm doing my best to hang in there. Thank you. Wish my voice were a little better today. Next slide, please. So this is where we get into what to do. How to have input if that's something you want. There's a lot of good stuff in this rule. And showing support for that, showing support for things like anti-discrimination protections in organ transplantation and cracking down on treatment providers pushing people toward hospice who could go on living and want to do that, and putting some pressure on states, pressure tied to their federal funding that they need to not casually take people's kids just because the parent has a disability label. Saying that this is important to our community in a big public way, saying that this is meaningful to us, will be useful going forward. If Congress ever looks at the Rehabilitation Act again, when the courts look at the Rehabilitation Act, we've had some very damaging court decisions around the Rehabilitation Act in the last couple years. And a public show of support for everything in this that's good is really helpful for keeping it intact and keeping it in place. These comments will help lawmakers, the courts, people in federal agencies understand how these changes affect our community. And there's also an opportunity here to say, we appreciate everything that's good and helpful and life-saving about these changes, but here are some ways they could be even better. And it's possible that HHS might even adopt some of those into a final rule. It's not certain, and I don't expect massive changes at this point. By the time a rule has gotten this far, agencies usually have a pretty good idea of what they want it to say. But it's something to think about. Not everyone who comments on this rule needs to answer every question or will answer every question. We're not going to answer every question necessarily in our organizational comments even, because some provisions in this rule have a really big effect on our community, and we feel like our community needs to have a significant say. There are other provisions where we're probably just going to reference other people or groups' comments and say, we agree with what so-and-so said. This is because these changes are so big that we're not the most impacted part of the disability community on every issue. And we always want leadership of the most impacted. The most powerful thing that HHS could hear, I think, from the kind of thoughtful, engaged members of the disability community who watch things like this webinar are personal stories. We've got the 50,000-foot view in our comments, and lots of other disability organizations we trust and work with a lot have that too. But if you've got a story about an interaction with the child welfare system, or a situation where you experienced discrimination in medical care, or circumstances where it was hard for you to get preventative care because the medical equipment available to do that wasn't accessible. If you can speak to one of the questions or several of the questions personally, that's the best thing that individual people who are interested in commenting can contribute. The comment period closes on November 13th, and that means that up until 11:59 p.m. on the 13th, people can go to the Federal Register and can submit their comments. We're going to talk a little more about how to do that on the next slide, and that'll be available to you after this presentation, once we upload the webinar and leave the recording up for people to revisit. So that's the deadline. Comments have to be in by November 13th to count. Next slide, please. I talked about this a little bit already, but here's how to write a good comment. And this applies to this comment period. This applies to pretty much any situation, really most situations, where a federal agency is doing something with a required public comment period, and you're interested in speaking out. It's really, really important to show a clear connection between the proposed regulations and the story you're telling. There has to be a link. Any bad thing that happened is not a good story for this purpose. Any bad thing that happened that was disability discrimination is not a good story for this purpose. A story that connects to the issues we talked about, the issues that this rule is trying to address, and that shows either why the changes that have already been proposed are important, or why we need more changes on top of that, is really what's helpful here. It's important to be narrowly focused on the issues in the rule as covered, as connected to HHS funding. Talking about other disability policy issues, even if they're really important, is not helpful. It just bogs HHS down in information that they really can't do anything with as part of this process. What's beneficial is to share that personal story about something, for example, discrimination in healthcare. A story that is close to you. So a story that is your own, that's a loved one's that you know well. not a story from a stranger, a story you saw on the news. Stories that are close and personal and have had an impact on your life are the ones that are going to be the most important for this purpose. It's called a public comment period for a reason. That's our next bullet point. Do not put private information about your life in your comment. Anybody can read these comments. They're a matter of public record. They're out there. Anything that needs to stay private should not go in one. This is not a good place to put intimate medical details that one doesn't want to share with the world, or one's home address or social security number. Also, don't send in pictures or videos. And again, I can't say this enough. This is not the time to talk about any policy issue except what's in the rule. That's frustrating, but this is a step in an intricate legal process. We want that legal process to move along quickly because we like a lot that's in these regulations. A lot of it will really benefit our community and help people in day-to-day life. And the only things that HHS can address as part of this comment process are things that really connect with the proposed rule. It's too late in the process to add a whole new issue to the rule. So it's really important to stay focused, and there's so many important policy issues we're up against, but keep to the ones that are in the proposed rule. Next slide, please. If you're interested in submitting a comment or reading part or all of the proposed rule, it's 400 pages long as a PDF document, a double-spaced PDF document. It's dense, but if you want to see it, it's out there, it's public, anybody can read it. To the extent that it's accessible to them, which it's not accessible to everyone, for sure. But if you want to try reading it or reading a part of it, maybe the part most relevant to what you're thinking of commenting on, that's something that you absolutely can do. If you decide to comment, we've linked in our slides the Federal Register page for the proposed rule. The Federal Register is where any rule that an agency is posting for public comment will always be. And it's where the agencies receive public comments. It's where the submission form is. There will be something you can click that says submit a formal comment. Ideally, upload your comment as a Word document. If you can't do that, it's also possible to type it or copy and paste the text into the comment box. And there's a little bit of a form. It's not terribly long, but you will be asked your email address. You'll be asked whether you're an individual person versus representing an organization, or whether you want to remain anonymous. I think it's great when people are willing to attach their names to their comments, but there are situations where people prefer to remain anonymous and have good reason for doing that, really need to do that. And if that is your situation, that's an option that's available on that form. And then there'll be a button that says submit. And that's all it takes to submit a public comment on this rule or on any proposed rule. This is something to think about, something to keep in mind. Not everyone knows about this, but this is a way for everyday people to have an impact on some very important things our government does. Next slide, please. Don't expect to hear anything back from HHS. They don't respond to comments. Not from organizations, not from individuals, by and large. But anything that goes in through that form will be seen by HHS, and there are requirements that in the law that somebody at HHS will read and respond to every comment, not necessarily in an individual email back to the person, but every comment is looked at. So every comment that tells a compelling story that's really relevant to the material in the rule matters. Every single one, whether it's from a big organization or a small one or an individual, whether it's from someone with disabilities or without, everybody who submits a comment will have their comment looked at. After that, after this part of the process where HHS accepts public comments and looks them over, the rule will be finalized, possibly with some changes, possibly without, probably without too many. And the final rule will be implemented, which means it starts being enforced. Now, the fact that this is not enforced now doesn't mean that HHS isn't taking discrimination complaints. People who think that they have experienced discrimination in a situation that's covered by HHS, especially healthcare, can still submit complaints to HHS's complaint apparatus, which is called OCR. But this rule is not enforced yet. It will be after the stage of the process. It will be a little bit later. And in the coming months, some version of this, probably one that's very similar to what we have now, will take the force of law and will be something that HHS is receiving complaints about and taking steps to enforce. We're also going to see other federal agencies whose jurisdiction touches on different parts of Section 504 of the Rehabilitation Act weighing in with their own proposed rules, and we'll be back in touch about those. Next slide, please. We've got our action alert out about this, and here's a reminder of our deadline. We've got just a few minutes left, and I think we've got some questions in the chat. Let's get to any that we can before we close the webinar.
We do. For the sake of time, I'm going to focus on the ones that are back questions. We have RV asking, do you name names of the facility or org you had the discrimination issue with, or phrase it like major hospital located in state name?
I don't think it matters that much, because this is not about what happened in the past. This is not a discrimination complaint made through an administrative process in a federal agency, and it's not litigation. This is creating policy that will apply going forward into the future. So, what happened last week or 6 months ago or 5 years ago is significant if it demonstrates, if it's an example of why the changes in the rule are important, or what additional changes would be helpful to the disability community. but HHS is not going to go back and punish people who may have engaged in discrimination. It's not going to do investigations based on what is in these comments. So I don't think whether commenters name names or not really matters. People who feel they've been discriminated against can talk to a lawyer or file discrimination complaints through HHS, but that's a separate thing.
And we have Nina asking, when it gets implemented, is there a sense that HHS will litigate on more issues? And then in parentheses, it says for enforcement purposes.
Yeah. This is a pretty good indication of what HHS leadership right now is interested in. Now, HHS leadership changes every time the presidential administration changes. So it's hard to say what that'll look like after the next election. But yeah, it's likely that no matter who is in power, this will give, well, it's certain that no matter who's in power, these regulations will give HHS more tools to enforce the law, and it'll give private attorneys more tools in litigation. It's also an indication of the interests of the people in charge at HHS now, which does give us some hints about the kind of enforcement they might do.
It looks like this may end up being our last question that we can get to today, because it's Vanessa Shea says, my primary concern when I am reading these updates is that, particularly as a parent, are they going to continue to reinforce that people need to follow that state standards, which when given the opportunity are legally used in a harmful way with little to no consequences that actually alienates people from their cultural identity? This is especially true for any marginalized community, because the false choice impressed upon people by lack of resources. Do you feel like what you have read protects from all that at all? Or is it not something that could be addressed in this space?
I'll answer this, and I hate to have us run long at all, but I also want to get to the next question or comment because it's important. I think this protects against that a lot, especially in child welfare. This is not pressure to enforce existing state standards or practices. This is pressure to have better ones. And it's tied to money those systems really can't function without. I don't think this is going to be followed tidily right out of the box. Not at all. Like, I'm not naive enough to think that for a second. But once some litigation and federal enforcement happens, I think states will take the hint, and there will be some improvements, particularly in child welfare. I want to answer Frida Tepfer's question about the Supreme Court. So this is not a process that Congress is a part of. Just to be clear, in case there's any confusion, this is something a federal agency is doing under a specific law called the Administrative Procedures Act that really defines and sets out this long, elaborate process for how agencies make rules. I took an entire semester-long class on this in law school. It's intense. And it's one of the most complicated bodies of law in the US legal system. But we've kind of given you the process in very broad strokes today. We've provided a little bit of an overview of the relevant parts of it. I want to touch on your concern about the courts, though. One reason that comments about the parts of this we like and a strong show of support for the parts of this we like is important is that we have seen damage to the Rehabilitation Act come out of our federal courts lately. and a strong show of support for the good parts of this, all the things that are exciting in this, may help keep them in place. And may also show any lawmaker who considers weakening this somehow, if that should ever come to pass, that there is support for this. There's a constituency that values this. And that's very protective. That helps this stay in place and helps this be durable and helps this continue to protect our community for years to come. But you're right. There's a lot of change going on in administrative law right now, and no one knows exactly what's going to happen. We're a little past time, so I want to close out our webinar for today. Thank you all for joining us and for the lively discussion. You all had really good, thoughtful questions and points to make.